whereas constitutional provisions themselves cannot be impugned. Thus, while the Senate vote under Articles 144 sub-article 10 and 145 sub-article 7 is final and beyond judicial review, the Senate vote under Section 33 subsection 7 of the County Act is susceptible to challenge. Courts may proceed to stay and quash a resolution to remove a governor and even halt the filling in of the vacancy, but such judicial interventions cannot be imagined in the case of a president or the deputy president. Third, the manner of filling in the vacancies also differs. Under Article 149, a vacancy in the office of the deputy president is filled by presidential nomination and voting in the National Assembly, whose vote stands final and is self-executing. By contrast, the Constitution does not prescribe how a vacancy in the office of deputy governor is filled. Section 32D of the County Act provides for nomination by the governor, approval by the county assembly, and appointment thereafter. This statutory process, unlike the constitutional one, is amenable to judicial review and may be stayed or quashed. It is therefore on account of these glaring differences that this court cannot apply mutatis mutandis, the jurisprudence on removal of county governors to the removal of the president or deputy president. Findings on governors' removal are squarely applicable to issues before us. We cannot run away from the same. This includes the pronouncement by the Supreme Court on the second case on the choice between plenary or special committee. In sum, therefore, whereas Article 144 and 145 embodies what may be termed as constitutional finality, the provisions of the County Act represent a form of statutory finality, thereby actuating the distinction between the two. We now turn to His Excellency Gachagua'S quest for pension and emoluments under Retirement Benefits Act. The preamble of the Act makes clear that it is an act of Parliament to provide for granting of pension and other emoluments, retirement benefits to persons who hold the office of Deputy President and persons who have served as Prime Minister, Vice President, Speaker, Deputy Chief Justice, or Chief Justice after 1st of January 1993 and for connected purposes. Section 7 of the Act provides for the pension and other benefits of a retired Deputy President or a retired Vice President. Section 2 defines a retired President as a person who, having held the office of Deputy President, has ceased to hold office as such in the manner specified in the Constitution. The interpretive question that arises is whether a Deputy President who ceases to hold office by reason of impeachment can be deemed a retired Deputy President within the meaning of the Act. Whether courts can legitimately interpret impeachment as retirement is a weighty and novel question. None of the parties address us on this issue. We are therefore of the considered position that it is not properly before us to pronounce ourselves on the same, for that will be presumptuous and will amount to stepping beyond the pleadings and the submissions of the parties. Accordingly, we decline to make any findings on this point. The parties are at liberty to pursue the matter further. An order of mandamus was sought to compel the National Assembly and the Senate to promulgate a constitutionally compliant procedure for removal of the Deputy President by impeachment. We find this prayer to be merited. For clarity, the lack of such legislation per se does not, however, impugn the instant impeachment proceedings. Next, having found that the fair trial rights of His Excellency Gachagua were infringed when the Senate declined to allow the adjournment, that is a vindication of His Excellency Gachagua. We, however, hasten to add that The violation does not have the effect of quashing the Senate's resolution to impeach His Excellency Gachagua for precisely the same reasons we have provided with respect to the finality of the impeachment process. If the Senate's resolution were to be quashed or set aside, then by operation of law, the status quo ante will be restored, thereby effectively creating a scenario where there will be two deputy presidents in office at the same time. The impeached deputy president, reinstated by judicial fiat, and the successor duly appointed under Article 149, sub-Article 1. We have no doubt that Kenyans did not intend such scenario, and the Constitution does not contemplate dual incumbency in the president. Accordingly, while the infringement of fair trial rights is acknowledged and vindicated, it does not undo the impeachment itself. The appropriate remedy lies in declaratory reliefs and damages to vindicate the Constitution, not in quashing the Senate's resolution. In light of the foregoing, that is not to say that His Excellency Gachagua has no constitutional remedies given the violation of his rights. As we said, we are convinced that this is a case where the infractions on the part of His Excellency's right can be adequately vindicated by way of appropriate declarations and damages. Applying Gitwabu Imanyara's case, it is our position that the violation of His Excellency Gachagua'S fair trial rights during the impeachment proceedings calls for a remedy that goes beyond mere acknowledgement. Declaratory relief serves to formally recognize the infringement, while damages will provide redress and underscore the seriousness of the violation. This amount is not intended to compensate for the loss of office, but rather to vindicate the Constitution, restore the dignity of the affected party, and deter similar infractions in future impeachment proceedings. Lastly, we find that since most of the prayers sought in the consolidated petitions have failed, coupled with the public interest nature of this matter, parties herein ought to bear their respective course. Given that the Gitwabu case was resolved a decade ago with Mr. Gitwabu receiving damages of 15 million, the lapse of time justifies an upward adjustment of the award.
These are now the final orders. Arising from all that we have said, these are the orders that we make. 1, the prayer seeking to quash the resolution of the Senate to impeach His Excellency Gachagua is hereby declined. 2, a declaratory order is hereby issued that His Excellency Gachagua'S fair trial rights were infringed when the Senate declined to allow an adjournment in the impeachment proceedings despite his absence. 3, a declaratory order is hereby issued affirming the constitutional necessity for Parliament to enact a dedicated statutory framework governing the impeachment of Deputy President under Article 150 of the Constitution. 4, the Court makes no findings on pension and emoluments. The first petitioner is at liberty to pursue the matter before an appropriate forum. 5, the Court awards constitutional damages of Kenya shillings 50 million to His Excellency Gachagua payable by the Senate to vindicate the Constitution, restore the dignity of the affected party, and deter future violations. 6, parties shall bear their own costs given the public nature of these proceedings. And lastly, for the avoidance of doubt, any prayer not expressly allowed herein is accordingly disallowed. Before we take leave of this matter, we wish to record our appreciation to all counsel who appeared in these proceedings and all parties for their industry, diligence, and the quality of their submissions. Your collective effort has contributed to the development of constitutional jurisprudence on this subject. We also extend our gratitude to the judiciary staff who worked tirelessly to support the bench in ensuring that this decision, the first of its kind under the Constitution 2010, was rendered in time. Thank you very much.
When her leadership, the Justice Dr. Mugambi, was reading part of the judgment, if I heard correctly, she said that the 10th respondent, UDA, filed written submissions on 28 August 2026. If my hearing is correct, then quite manifestly that is a typo that the court might wish to correct. Secondly, the first petitioner applies to have a copy of the judgment, one, and two, typed copies of the proceedings, and three, a complete set of the video recording of the proceedings. We would wish to have those as quickly as possible, of course, upon payment of the necessary court fees. It's a long judgment, and I am sure the first petitioner will want to be advised once we as counsel understand each of the issues addressed in the judgment. This honorable court has rendered its opinion, so there is nothing to be raised with this honorable court. But once we understand each issue by reading the judgment, the proceedings, and the video recording, we will then be in a position to advise the first petitioner, for example, on whether to pursue his other rights, as this court has indicated. I thank the court.
Thank you.
May it please you, my lords, my lady. Njeri Maina for the third petitioner. I wish to request for the typed certified proceedings and the certified judgment. And my lords, my lady, for the tidiness of the proceedings, I request on behalf of all other petitioners in this matter. The third petitioner has already filed their notice of appeal. We request that you expedite the proceedings and the judgment so that we can take it on from here. Thank you.
My Lord, my name is Gachagua'S. I have sat here for approximately 10 hours listening to this judgment. I certainly have heard you clearly and the disposition. Equally, despite it being the judgment of the court, I do not agree with some of the issues that the court has deliberated and the conclusion the court has arrived at. And most importantly, my Lord, when we came before you, we only did not just come for judicial recommendations on legislations. We thought that, my Lord, we'll leave this court with a clear judgment on how a violation ought to be dealt with. When we came before you, my Lord, and we moved you, most importantly, on the issues of constitutionality of the manner in which the proceedings were conducted, We did not come here for a remedy of a legislation. It will not benefit my clients whatsoever. And for that reason, my Lord, and granted the dissatisfaction with your judgment, I have equally advised my clients, for the 4 to the 49 petitioners, to launch and prefer an appeal. For that reason, my Lord, would wish to be supplied with certified copies of the proceedings, the judgment, and the transcript. And for the reason, my Lord, that we need the transcript is that, my Lord, part of what was delivered by Justice Murima when he was deliberating on the issue of the plenary and the committee, I can tell you, I had never heard what he said and what he concluded. I therefore, my Lord, would wish to have the transcript provided in verbatim, so that, my Lord, we're able to deliberate and internalize them. We are otherwise not dissatisfied. We are otherwise dissatisfied, and we shall not watch when the Constitution is being buried. Thank you.
Your Lordships, my lady, my name is Gachagua'S for the 10th to 41st petitioners. And my Lord, I would like to request for the same materials that Senior Counsel Paul Mwita has requested for. Thank you, my Lord.
My lords, my lady, I do associate myself with the submissions of fellow counsels. My lord, there is a new twist into our constitutional